What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta. I am a lawyer in Central Minnesota. I own my own law firm, which is Rekieta Law. Today, I am going to do something a little different. I am going to talk about two lawsuits, but I am not going to read them to you. I will provide some links in the descriptions to these lawsuits. You can read them for yourself, but if I read through both of these lawsuits, it will get exceedingly long, and I'm looking to do a shorter video tonight. So, the first lawsuit is Tyler Watson versus Dick's Sporting Goods. Tyler Watson is also suing Walmart, both in the state of Oregon. And what his allegation is that he went into both Dick's Sporting Goods and Walmart and attempted to purchase a firearm. He is 20 years old, and Dick's and Walmart have created a new policy in which they state that they will not sell any firearms to persons under the age of 21. Tyler is claiming that this is a violation of this statute, which is discrimination in places of public accommodation under the Oregon statutes, 659A.403. The relevant language here says that it is basically unlawful, or that all citizens in the jurisdiction are entitled to the full and equal accommodations, advantages, facilities, and privileges of any places of public accommodation without any distinction, discrimination, or restriction on account of, and we can skip all this stuff, age, if the individual is of age as described in this section or older. So in this case, subsection 1 does not prohibit the enforcement of laws governing the consumption of alcoholic beverages by minors and the frequenting of minors by places of public accommodation where alcoholic beverages are served. The enforcement of laws governing the use of marijuana items as defined in Oregon statutes by persons under 21 or frequenting by persons under age 21 of places of public accommodation where marijuana items are sold, or the offering of senior discount rates to persons 50 years of age and older. So the problem in this lawsuit is that the law as written only protects these three categories of age, and outside of those, it does not recognize the discrimination based on age as discrimination in a place of public accommodation. So this lawsuit is unlikely to succeed as the law is written, and what they should be doing is challenging the constitutionality of this lawsuit in failing to protect all of the age discrimination that could be out there. I do not think they're likely to win this case, but it is going to get people talking about this stuff. So this case is distinctly different from another major case on gun rights, and that's the NRA versus Florida. And I'm not going to go through this whole case. What I am going to focus on is a couple specific spots. So the long story short in this case is that the state of Florida just passed a law banning the sale of firearms to anyone between the ages of 18 and 20 years old, despite them being of age to purchase firearms under federal law. Although they cannot buy handguns until they are 21, they could buy rifles and shotguns at the time they reach the age of 18. Despite them being lawfully of age in several categories, they have determined that they will no longer sell guns or allow the sale of guns to persons age 21 or under 21. Importantly, this does not just apply to federal firearms license sellers. It also applies to private sales and transfers. So an 18-year-old kid could not buy a rifle or a shotgun from his uncle or grandpa or something like that. He would have to wait until he is 21 years old. I say 18-year-old kid. I know he is a legal adult in most matters, but not in this one. So, count one. Let's go through the counts very briefly. This is 42 Usc Section 1983. This is the statute in which you use, the federal statute, which you use to sue an infringement of rights by your government agent. In this case, the Attorney General and the Director of Law Enforcement for the state of Florida. So, The Second Amendment's guarantee of the right of the people to keep and bear arms secures to law-abiding, responsible adult citizens the fundamental constitutional right to purchase and acquire firearms for the purpose of self-defense in the home. U.S. Constitution Amendment 2. It's weird that they limit it to the purpose of self-defense in the home, because it does not so limit that in the Second Amendment anywhere. It just says the right of the people to keep and bear arms shall not be infringed. The Second Amendment applies to the state of Florida under the 14th Amendment. If you don't know, the Bill of Rights did not apply to the states until after passage of the 14th Amendment, and until said rights were challenged and applied to the states through the 14th Amendment by the Supreme Court. In some cases, this took a very long time. I believe the Second Amendment right was not actually applied to states until somewhere in the 1930s. I could be wrong on that, but it's been a long time. It may actually have been longer, because states have been remiss to do any sort of regulation on gun control until recent years, actually. So then the Florida statute bans law-abiding, responsible adult citizens between the ages of 18 and 21 from purchasing any firearm from any source. The ban infringes upon and imposes an impermissible burden upon the Second Amendment rights of NRA members as described above, and is therefore facially unconstitutional, void, and invalid. So this is the facial challenge. So this is challenging the wording of the bill itself. It is facially discriminatory between persons 18 years of age to 21 years of age. That's the text of the bill. So this next count is an applied challenge through 1983 for violation of the Second Amendment as well. So in this case, it says that this ban particularly infringes upon and imposes an impermissible burden on the Second Amendment rights of those NRA members described above who are female, which doesn't make any sense. It doesn't particularly infringe upon the rights of females versus males. It is applied equally. Facially, it is equal, and as applied, it is also equal. But they've got some sort of argument here. They say females between the ages of 18 and 21 pose a relatively slight risk of perpetrating a school shooting, such as the one that occurred at Marjorie Stoneman Douglas High School, or for that matter, a violent crime of any kind. For example, in 2015, women in this age group accounted for only 1.8% of arrests for violent crime, while males in the same age bracket accounted for 8.7% of such arrests, and males between 21 and 24 who may lawfully purchase firearms under current law accounted for 9.2%. Regardless of its facial validity, Florida's ban is therefore unconstitutional, void, and invalid as applied to women between the ages of 18 and 21. They don't do a very good job of distinguishing what about this applies differently to women as it does to men. Their argument is probably along the lines of, if you're trying to reduce crime, reducing it against women doesn't make sense. But if they were to facially discriminate between women and men, it would be even harder to pass this law. So I'm not sure what the NRA attorney's logic is with this complaint. It's not actually applied differently to women or to men. So that doesn't make any sense. Unless you're trying to say that more men will be banned from between the ages of 18 and 20 from purchasing firearms because more men, because more men would commit the crimes than women, but it just really doesn't add up. So this argument, in my opinion, is not very good. So the next is a violation of the 14th Amendment's Equal Protection Clause, a facial challenge to it. Same thing, it bans law-abiding adults between the ages of 18 and 21 from purchasing firearms, but does not ban the purchase of the same firearms by law-abiding adults aged 21 and over. So there is a facial discrimination between the ages 18 and 21 and 21 plus. So that is, that is at least a logical application. And then here, the fourth count is an as-applied challenge. And again, they're stating that this somehow affects women without any compelling justification. This is weird. And I'll talk about why it's weird in just a moment. But so as applied to women, again, this facially applies to women in the exact same way as it does, or this facially it applies to women the exact same way as men, but it also, as applied, will impact men in the exact same way that it impacts women. So making a discriminatory argument on application, I mean, I guess you make it, but it's not a good argument at all. I mean, these two counts, count 2 and count 4, are completely pointless. Count 1 and count 3 are sufficient to bring the action. Now, will they win? And what is the difference here between this and the Dix lawsuit? So the Dix lawsuit, as I stated, was a lawsuit challenging the policies of private companies under state law, under existing state law. This lawsuit is challenging the state law in its constitutionality. So the NRA is actually saying that this portion of the law that applies to the ban of firearms between ages 18 and 21 is unconstitutional. It is not permitted because of the equal protection clauses of the 14th Amendment and the fundamental right to keep and bear arms guaranteed by the Second Amendment, and therefore it must be struck down. So in the Dix lawsuit, the court will be deciding whether or not the state law covers and therefore would allow the discrimination for the sale of firearms. And in the NRA versus Florida lawsuit, the court will be determining if this portion of the law is constitutionally valid. So let's talk about how the court analyzes these types of questions in the NRA case. Because the Dix lawsuit case is going to be one of statutory construction and interpretation, and it will be fact specific. So if they determine that age is protected in regards to firearm sales, then the plaintiff wins, period. That's just how it will be. If they determine that age is not protected in regards to firearm sales because it's not in the statute, the plaintiff loses. Game over. There's not much else to do. They would have to bring a different suit to challenge the constitutionality of omitting gun sales from the public accommodation statute. But the state of Oregon doesn't limit the ability to own guns. So having it not protected in places of public accommodation is a much different question than NRA versus Florida. So here we go. In NRA versus Florida, whenever you have a constitutional challenge to a fundamental right or a challenge to a statute that infringes upon a fundamental right, the court applies one of 3 types of scrutiny. The lowest level of scrutiny is rational basis, which means that the statute has to be rationally related to a legitimate government interest. So if it doesn't matter what the stated purpose of the bill is, if there is a legitimate government interest and the statute rationally relates to achieving that legitimate government interest, the statute is valid. This is the lowest form of scrutiny. When it's applied, the government almost always wins because they can pick anything. They can pick anything. The next level of scrutiny is intermediate scrutiny. And intermediate scrutiny says that you must have an important government interest, which is above legitimate, right? So it must be important, and the law must be substantially related to that important government interest. So you don't get to just pick a random interest anymore and see if it's somehow related to it. It has to be substantially related to furthering that government interest. I will tell you the stated purpose of this bill is to reduce gun crimes in the state of Florida. Reduce violent crimes, reduce gun crimes, and specifically the type as perpetrated on the school, Marjorie Stoneman Douglas High School, in the past couple weeks here. So that would be the stated purpose, and then the state would have to argue that this is significantly related or substantially related to achieving that purpose. NRA would have to argue that it is not substantially related to achieving that purpose. The final level is strict scrutiny, and strict scrutiny likely does not apply here, but that is having a compelling government interest, and then having the least restrictive means to achieve that government interest. That is a very hard bar to pass, and typically when strict scrutiny is applied, the citizens tend to win over the government. That's just how it goes. But strict scrutiny is really, really limited in its scope. It is generally applied to facially race-related restrictions on fundamental rights. For example, if this law were passed saying that all black people or all Hispanic people could not own firearms or could not purchase firearms, that would probably rise to the level of strict scrutiny, as those are underrepresented minorities who have historically been oppressed or disfavored under the law as far as constitutional review type questions go. That's what strict scrutiny is reserved for. In this case, it's not going to happen. The most likely outcome, though it hasn't been, we don't have any cases stating that what scrutiny age would use, and we don't have any cases stating what scrutiny Second Amendment firearms rights would use, but it's implied in DC versus Heller that that this would be an intermediate scrutiny case, since it involves the infringement of the Second Amendment rights. Despite the Constitution's absolute bar on infringing Second Amendment rights, the court will apply intermediate scrutiny to see if they can infringe those rights. That's just the way that the law has developed since the writing of our Constitution, for better or worse. But in having this intermediate scrutiny, what they will do, like I said, they will try and state that this is furthering an important government interest. Protecting the health and well-being of your citizens is almost unquestionably an important government interest. The NRA would have to challenge the very words of the bill, stating that its purpose is to protect the health and safety of the citizens of Florida. Because if that is truly the purpose of the bill, then that is definitely an important government interest. The government of the United States and the governments of each state are charged with providing for the defense of their people from enemies both foreign and domestic. Pretty much every state officer takes some sort of oath to do that specifically. So definitely an important government interest. And then the next part is determining if it is substantially related to that government interest. And that's where the NRA's arguments are really going to come into play here. And that's where these crime statistics are going to come into play as well. So according to their use of the FBI data from 2015, women in this age group account for 1.8% of arrests for violent crime, and males in the same bracket account for 8.7% of arrests for all violent crime. Now, not all violent crime is going to be gun crime. So what they're going to say is we would have, this is affecting approximately only 10% of gun crime, of any crime, any violent crime. So only 10% or so of any violent crime is being impacted by this bill, and gun crime is going to be some smaller fraction of violent crime. So what they'll say is that, look, it is an important government interest to protect the lives of the citizens, but this bill as applied is not going to be substantially related to that government interest, because the amount of crime, the amount of gun crime specifically, that it would be limiting would be so small, because not only is it only limiting the subset of gun crime from the subset of violent crime that's going on here, and the limited 10% of the violent crime, it's only going to apply to people who newly purchase a firearm and then subsequently commit crime with that newly purchased firearm. That's a much, much smaller percentage. And this is probably the NRA's best method of attacking this bill, is stating that, look, the number of 18 to 20-year-olds who purchase a gun and then use that lawfully purchased gun in violent crime is probably extremely small. Extremely small. I don't have the data on it. There's got to be some sort of, I say there's got to be some sort of data, but there probably isn't. So they might have to do some specific studies or reach out to some research groups to try and pin down this data. But it's such an extreme subset of overall violent crime when you talk about limiting the ability of an 18 to 20-year-old to purchase this weapon. What the NRA is going to argue, likely, is that while instances like Marjory Stoneman Douglas High School are tragic and awful and shocking to the sensibilities of the entire populace when they happen, they are exceedingly rare, given the amount of schools that we have, the amount of guns that are available, the amount of school shootings that actually occur, especially school shootings of this nature, are really, really rare. And further, they would probably try and pin down the type of firearms purchased how they were acquired, and then limit it even further. For example, if you go back to Newtown, Connecticut, Adam Lanza did not actually legally purchase the firearm he used to shoot up the school in Newtown. He, I believe, murdered his own mother and took her firearm away from her. So, you know, that would be this bill presumably would have no impact on his ability to achieve the gun in the way he did. And if we're talking about major school shootings, which are, despite articles to the contrary, exceedingly rare, when we're talking about actual mass shootings at schools in the way that the Marjorie Stoneman Douglas High School shooting occurred. You know, it's not gang related. We don't know that it was related to a personal conflict of any kind. This looks to be a mass shooting that is very hard to predict and random, unless you count all the times that this person was specifically reported for stating they were going to do a mass shooting. This doesn't appear to be connected to some other things. Some school shooting, there's a statistic out there when this school shooting occurred that this was the 18th school shooting, I believe, in so far in the year of 2018. But, you know, the other school shootings that they're talking about is someone, for example, commit suicide via gun in a car in a school parking lot when no one was present at the school. That's not a school shooting in this way. That's actually not even a violent crime. So limiting that, and I believe that person was something like 40 years old as well. So in that case, you know, this bill would have no impact on something like that. So the NRA's job in this lawsuit is to limit down the categories of people between the ages of 18 and 20 who lawfully purchase a rifle or shotgun and proceed to commit a violent crime involving that lawfully purchased weapon. And when they do that, it's going to show an absurdly small number of violent crimes that would be prevented by this bill. And that's how they're going to attack the substantially related to an important government interest, because they're not going to be able to challenge the idea that reduction of crime is important. They're just not going to. But challenging the ability of this bill to curb that crime, that is a potential avenue they have to win. But it's important to note that this is the type of case that is ripe for Supreme Court review. One, it's novel. We don't have this type of age discrimination arriving before the Supreme Court. Two, it's facially discriminatory. The text of the bill states that people between 18 and 21 years of age are discriminated against specifically. They are otherwise allowed to do this except for this law in this state. Three, so one was it's ripe because we don't have we don't have a ruling on age discrimination in this manner in the Supreme Court. Two, it's facially discriminatory. And three, it involves a fundamental right, which is gun ownership. And the court has not been taking up gun ownership cases, but none of them are as facially discriminatory against people as this one. The other cases involve the sale of, you know, quote unquote, assault weapons. There's an assault weapons ban in the state of Connecticut, I believe, and the court refused to hear it. And the other one was a 10-day waiting period in the state of California, which the court refused to hear as well. Those are not actual, I mean, they're infringements on Second Amendment rights in some respect, but they are not actual bans of a specific group of people in the way that this is. So this is definitely ripe for Supreme Court review. By the time it gets up to Supreme Court review, will likely be almost 2 years from now. The Supreme Court may, in fact, hear this case. And the reason I say this is going to the Supreme Court is because this is the type of case that has significantly deep pockets to push an appeal all the way through and significant public interest to push an appeal all the way through. The NRA's sole job, according to them, is to protect Second Amendment rights. And also provide for responsible gun ownership. But their sole job as lobbyists is to protect Second Amendment rights. So they are going to, if they lose, appeal this immediately. And then if they lose again, they would appeal it to the state Supreme, or they would appeal it to the Supreme Court. That's just how they're going to do it. The state of Florida, if they want to stick by their guns on this, if they lose, they are likely going to appeal this as well, because this is a challenge to their legislative authority. That's just how states work. Whether or not it's the right challenge to do doesn't really matter. They're going to want to see what their limits are in restricting this thing, because if they win, they get the way this goes. If they lose at the Supreme Court level, then they know how to craft further legislation. So this is almost definitely going to the Supreme Court. It's a matter of long time before it gets there. But those are the types of questions that need to be answered. Again, is this an important government interest? Probably. Is this bill substantially related to furthering that important interest? I don't think it is. The NRA clearly doesn't think it is. And that will be the ultimate question, is whether or not the courts agree. And a whole bunch of people are going to chime in and provide data on this through amicus briefs once it gets past the district court level and into the appellate courts and the Supreme Courts. And this will probably be a big case in a couple years. But that's the main difference, guys, between the Dix lawsuit and the NRA lawsuit. I will provide links in the description so you can check out what these lawsuits are about. You can read through them. If you have questions about specific language in these documents, please feel free to put them in the comments. I have read through the documents. I can answer questions about them absolutely. If there's a significant question that requires enough, text, I'll go ahead and make a follow-up video to it. But as for now, that's the state of these two cases, the differences between them, and the main issues involved. So I hope you found this video informative and fun and not quite as long as my other videos. If you have questions, please drop them in the comments. If you have criticisms or hate the content, please drop those in the comments as well, so I can go ahead and make it better for you. If you have any cases or questions that you would like, check me out what do we do? Right up here, patreon.com/lawsplaining. You can join me as a patron, and you can suggest content for me or ask questions. If you are a $5 or higher patron, you get access to the Discord channel, and you can talk to me directly. So yeah, go ahead and stop by. Even if you don't want to subscribe, go ahead and check it out. I believe you can have access to the audio versions of all of the videos that I do as well. Since the video formats do get kind of long, some people like to listen to the audio, and that is available there as well. Anyway, y'all have a nice night. I'll see you in the comments. Peace.